Hi, my name is Janice Switlo, and in this episode I'm going to take you through page of the Anishinabek Nation Governance Agreement, commonly known as the ANGA. Now, I'm going to start with some general comments and summary comments, but as I said, I am going to take you through the whole thing because nobody is getting independent legal advice on this in terms of the people. And it's my hope, my gratitude goes out to whomever it was that was able to get an actual initialed copy. I know there's been circulating drafts that say these are not final drafts. There's really no point in me reviewing one of those. So I was able to go through this as an actual final draft that's been initialed. And I wish I could say I'm happy to share this with you today. But this is not a pleasant exercise. I'll be honest, I'm tired. I've been through this a few times, making sure I got every point. And it's really not a pleasant enterprise to be sharing this with you today, but it is important that you know these things. So I want to first start, in structuring any deal. The idea is you want to make sure you're going to get what you're going to get. So a classic is, whenever you want something constructed, for instance, you don't pay them all the money up front. There's many examples of people knocking on doors, especially elders, and saying, I'll put a new roof on, I'll do whatever that needs to be done. You give them the money and you never hear from them again. In this situation, if you do pay up front and give everything up front, you really have nothing to leverage to ensure that what you're expecting to get, you actually get. Here in this deal, agreement, you're handing it all over and you have nothing in terms of firm deliverables. It's very important to appreciate that. You should never go to the people until it's clear this is exactly what you're going to get. You may want to build a pool, for instance, right? That same analogy, resort area. But the only thing you get is a backyard shed that holds the foam noodles that you use to float in a pool. And there's really nothing you can do about it because you didn't do your deal right. You didn't have your side covered and protected. And that's really a summary of this. If this is indeed what you want to do, then for goodness sakes, make sure you're going to get what you think you're going to get. So on a very base level, there is no way in any other context of law, the practice of law, that an agreement like this would expect to be signed by one party that is put in the position that you are in this deal. To the chiefs, I don't know that you really. Here's the thing. I was really confused. Why were the chiefs not having a copy of the final draft, for instance, a copy of the agreements? I couldn't understand that. I quite frankly thought some chiefs were lying. How could you not have it, right? You're there negotiating. But I finally get this. I understand why they are not negotiating it. Okay, a provincial incorporated body is, not the chiefs. And under this agreement, if you can believe this, the operative language is they're required, the Union of Ontario Indians, they're required, a provincial incorporated body, they're provided to give information, not information, and I'll quote it later here, but just a summary. They're provided to tell of the agreement, but not give access to the agreement. So that's satisfied by saying, yep, we have an agreement, there's an agreement, and we've initialed it. No can initial and go ahead and do that without being required to provide a copy to the chiefs. So people out there, when your chiefs have told you, we don't know what it is, we haven't received a copy, believe them. I know I didn't at first, but I do now. And it's tragic what's happening here for chiefs. Essentially, they're going to be caught in the middle. All the people are going to come to the chiefs and say, I have these needs, etc. But the chiefs are going to have no power. They're not going to have any control of money. And they're going to be caught in the middle because it's this new umbrella body that will get the money and make decisions. And so I would hate to be a chief under this being in effect, because there you are receiving all of the concerns, issues, what have you, of your people, and having no power to address them. So, and the other big thing here, before we get into the details, here's the distinction. The Indian Act was passed. It did not purport to incorporate any of the bands or the chief and council as those definitions are contained in the Indian Act. That Indian Act goes way beyond the administrative requirements as set out in treaty, for example. Canada is supposed to be your, civil service, your secretary, free staff. Okay, but it went further. Indian Act interfered in who you are, your governance, all that kind of stuff. To this day, Indigenous peoples have never agreed to that, didn't accept it, and that can always be shown to be an unconstitutional and unlawful interference with your existing governance and the fact of nationhood. Through this agreement, the ANGA, you're actually accepting not only the Indian Act, but you're accepting more Indian Act. And you'll see what I mean as I start to go through that. It's important to understand there's two levels of incorporations happening here. There's like the umbrella, which is the quote-unquote Anishinabek Nation entity. And then there's the individual Indian band entities titled First Nations. It's also important to understand that much of this removes the duty of fairness on Canada. You enter into this, any that do not have a treaty in place, you are no longer able to demand a treaty. So you will no longer be able to trigger Crown duty of fairness to deal with you as the Queen, as the Crown has dealt with other Indigenous nations elsewhere and entered into treaty. You're stuck with only more of this stuff and possibly even a land claim settlement agreement, though I don't know that that'll even be necessary given what you give up here. Okay. So you ready? Hope you have a comfy seat. This will be a little bit longer and a little bit choppier, if you will, episode, because I do need to have to flip back and forth on the agreement. So on page 7 of it, there's the preamble. It's important to understand that preambles are not actually part of the agreements proper unless there is a clause in the agreement that says the preambles constitute terms of the agreement. There is no such clause incorporating the preambles in the agreement. So anything in the agreement that is under preamble is just flowery language, it's words. It does not constitute, it does not form part of the actual agreement. So on page 7 in the preamble, there's lots of nice Anishinaabe language, speaking about how the creators placed you here, gifts given, etc. Creator also gave Anishinaabe 7 sacred gifts, etc. So people, this is hard stuff to review, right? I mean, it's even, to be honest, boring for me to go through this kind of stuff. So people, are expected, the intention of this here can only be concluded to be that they're trying to comfort you, to say, oh, okay, this page is here, this is all good stuff, this is traditional statements, so this must be a good agreement. I'm not going to read through the rest of the 60 pages that I don't really understand anyhow, no disrespect, it's just you're not a lawyer. So this tells me what I need to know. It says, Creator gave us sovereignty to govern ourselves. This is not sovereignty and governing yourselves. This is giving that up. I want to be absolutely clear about that. You are coming under Canada. You're embracing the Indian Act, and you're essentially embracing amendments to the Indian Act. But furthermore, it goes worse because, as I said, you're actually agreeing to be incorporated. Not you, the people, you're not being asked on this, but you will be in terms of a vote. So here's the part, this is where I get upset when I read this last one in the preamble. And again, it's written in Anishinaabe and then English. We respect and honor the past, present, and future. Not with this agreement, do you? You disrespect. You are saying, in effect, because this is all under Section 35, you're saying your ancestors were beasts of the field. You're saying that the doctrine of discovery is good law and that you agree with it. And you're saying that as a result of something that was passed in England in 1982, that somehow that caused your sovereignty to collapse and you came under and part of Canada. Were you asked to agree to that? Did you consent to that? No. That was something that was done between the Crown and her Canadian government. It did not involve you. But here you are wanting to be part of it. And worse yet, wanting to be part of it without even, you know, if you're going to give it up, at least get the per capita, the per person payment that Canada gives when they get your surrender. Okay, so now also when you see a clause that starts with whereas, okay, that's also part of the preambles. Okay, so now we have, you know, this is not covered by Anishinaabe language, it's all in English. But the first three ones sound great, right? It talks about the history of, and it talks about Ojibwe, Chippewa, Odawa, pardon my pronunciations, Potawatomi, Algonquin, Nipissing, Delaware, and Mississauga tribal nations. These are not defined terms in the agreement. And remember, this isn't incorporated because it's a preamble, who share a sense of Aboriginal identity and spirituality and are united through historic origin, values, language, traditions, and cultures. They are among that which comprises the nation. First Nations assert that they maintain self-sufficient governments with sustainable economies, etc. First Nations assert they have a sacred duty to ensure the well-being of the people. Now, further down on the same page, remember that's First Nations, that's bands as operating under Chief and Council. This is whereas the parties acknowledge that an assertion by one party is an expression of that party's position and does not represent acceptance of that position by the other parties to the negotiations. Well, the only one making assertions is the native side of things here, if you will. So basically what this says is that Canada does not accept any of those statements. And why? Well, because this is under Section 35. The existence of Indigenous nations, as those, you know, were identified up there, the existence is completely impossible where this is being done under Section 35, because Section 35 says, you know, it's all the Crown. You're coming under. You're part of. So, and it's clear here, whereas the First Nations were represented by the Union of Ontario Indians in the negotiation of this agreement. So your chiefs were not. It was the Union of Ontario Indians. This is a provincial company, and if you don't believe me, it's right in the agreement. The Union, in the definitions, the Union of Ontario Indians means the body incorporated under the laws of the province of Ontario. It also continues and says its successor. This is an example of poor legal drafting because it's not clear. On the first draft I read on province of Ontario or its successor, which can mean, oh, okay, in case the province of Ontario becomes something else, like what, part of a republic. But I suspect what they intended here was Union of Ontario Indians or its successor, because once this is passed, there's a renaming of it to become Anishinaabe. That'll be done because we'll have this new body incorporated. Difference being, Union of Ontario Indians, a provincial company, just said we represent Anishinaabe Nation. They are not Anishinaabe Nation. They just represent, so they were given money to negotiate this thing. And, I mean, without having chiefs, for instance, of each Indigenous community, the Indian band, it's Indian band, that's how this is structured. Without having them there as a check and balance, and you've got this body who's a provincial company negotiating for its own power, for its own control of all the money. That's a blatant conflict of interest, quite frankly. Where's the protection in the negotiations for the people? Where's the protection in the negotiations for chief and council and the monies that they're accustomed to dealing with in order to meet the needs of their people? You know, that's what's missing here. So back to it. Now we get into actual terms of the agreement, and this is in definitions. You know, you have Anishinabek Nation means the collectivity of First Nations, which is defined as Indian bands, as set out in Schedule A. Here's, you know, there's a definition. Means a person who is a citizen of a First Nation as defined in that law. This is the membership codes that are being passed. I'll spell it because I cannot pronounce this. E''BENDAAGZIJIG. I've come across that term before because, of course, I was given one of these things to review. It was absolute crap. The worst legal drafting I have ever seen. But it purports to hand over authority to, regarding decision making, to chief and council. Chief and council then, by authorize the chief. It's the chief then that steps into the body of this new other body, and then initially is one of, say, 22. Say everyone goes into this, one of 22 chiefs that form this decision making body. But that's only temporarily. Wait and hear what happens. So the effective date of the agreement means the date that this agreement comes into legal effect under federal legislation. There's nothing required for the nation because you're saying you're under Canada, you're not actually a nation. You know, this comes into effect once you're incorporated under the legislation. Now think about treaties with the Crown. They didn't come along and say, hey, first, before we can do a treaty, I need to incorporate you under my laws. Well, then it wouldn't be a treaty, right? Because you'd be under those laws. So here, if people are actually thinking that this is somehow an exercise of sovereignty, I'm sorry, but you don't get incorporated under another jurisdiction and say you're exercising your own jurisdiction. That's just ludicrous, right? And I'm sorry, I shouldn't laugh because it's pretty sad. People are actually, I think, being told this. I think I've seen articles written or whatever, propaganda, if you will. This is a start. This is a first step to exercise. We're just starting to exercise. No. You've closed the door on exercising your jurisdiction. You're exercising Canadian jurisdiction as permitted by Canada. And remember, because this isn't a treaty, and it's only under Section 35, and it comes within that full doctrine. Remember, Canada can decide, and by the way, money's always subject to appropriation. So if there's no money, how are you going to exercise it anyhow? All sorts of ways to say that you get nothing really under here. You have no clout, you have no power, you have no way to insist on any of this, particularly funding. So to be clear, once you enter into this, you lose the ability to insist on a treaty from the Crown. You may be able to resort to land claims. Definition of First Nation is a ban for purposes of the Indian Act. The only thing in the First Nations government means the government of the First Nation, which is the Indian band, represented by its Ogima. So all they're doing is, instead of saying chief counselor under Indian Act, they're using an Indigenous word, Ogima. Now, the Grand Council is defined, and it means the law-making body of the Anishinabek Nation, and is comprised of a Grand Council Ogima, a deputy Grand Council Ogimak, and a representative of each First Nation of the Anishinabek Nation, all of whom must be, citizens under that membership code. Until that gets changed. In section 10.4, listen what happens next. The Grand Council Ogima, the Grand Council Obiak, and the Obiak of the First Nations of the Anishinabek Nation will be the Grand Council until the Anishinabek Nation, this is the umbrella body, this isn't you as members, you've got no role in this, chiefs have no role in this, until the Anishinabek Nation selects its representatives under its leadership selection law. So again, it's not the First Nations putting this, it's this body, this new corporate entity. So it starts as a body of all the chiefs, but it's not going to stay that way. Now, if this was going to be up front and fair to the people, and you actually were going to put these questions to them, you would have a schedule attached to this agreement that sets out specifically what that leadership selection law will be. The concept is that it needs to be passed in substantially significant form and attached to a schedule. So you know what's going to come down. Because this leadership, now you guys know Indian politics better than I do, leadership, although I know a lot, leadership selection law could end up, theoretically, as a dictator. So, and again, the people you'll have no say in this, absolutely no say. And the chiefs themselves will be involved till that one stage. And based on how the chiefs have been treated through this whole process, I'm not confident that they will even, and this is not a reflection of their capacity and ability and intelligence. This is a reflection of the slyness with which this has been done and what people are saying, those that want it done and put in place for their own benefit, quite frankly, want people to think it says. So again, it starts out, but very quickly, and there's a provision, I think it's within 21 days, they actually have to get that done. So it's probably sitting there ready to roll, but no one's seeing it, and it's certainly not attached as a schedule. Now, here we also have, a definition of an implementation plan, and there's a chapter on that. But here's another good one. The implementation plan is not part of the agreement. So, you're going to sign off on an agreement. Do you know the track record of Canada for implementing anything? Have you talked to anybody who's done a land claim? They've got lobbying groups formed to try to get Canada to implement agreements. And so this is put in here, this is just deception, okay? It's described in Chapter 16, described, right? But it is not, and when we get to Chapter 16, remember this, but it is not part of the agreement. You're going to do something so major, you want to make sure it's going to happen. Again, a schedule with an implementation plan set out in significant detail with the proviso, a term of this agreement that says, this implementation plan must be completed. It must be confirmed substantially in the form as exists in Schedule X. And if it's not followed, the deal's off. Right? You have leverage there at least. Definition of international legal obligation. It only reflects on Canada. It says it means an obligation binding on Canada. Why? Because you're no longer any part of an international body. You have none when you're under Canada. There is only Canada. Again, definitions. Ogima means a chief of a First Nation, and First Nation, remember, is defined as an Indian band. And again, we already covered off the Union of Ontario Indians. Remember, a provincial body. This was not the people presenting to the Crown their representatives in order to engage in a treaty that describes some sharing of jurisdiction or dividing of jurisdiction. And remember, this is not a treaty. This is a domestic agreement. For greater certainty, and how is this, what laws apply? How is this to be interpreted? Well, it's to be construed, and this agreement is to be construed and interpreted in accordance with the laws in force in the province of Ontario. And the federal court has jurisdiction to hear questions on it. Another important point, people say, well, what's this? Section 1.5, Statutory Instruments Act does not apply to any of the laws passed under this thing by these two new, when I say two new, the one party is the schedule of bands that agree to be incorporated. I'll just refer to them as one because they're one party, if you will, right? Why is this act not apply? Because there is none of these new incorporations are regulation-making authorities. I'll talk about regulations as we come to that. It's important to know. Now, what's going on? What's the purpose of this agreement? This is what's binding, not the preambles, not the flowery language. It's designed to make you feel comfortable that this is a good deal. It's not. Not if you wish to actually respect past, present, and future and maintain your nationality as an Anishinaabe person. The establishment of a new government-to-government relationship between the parties within the framework of the Constitution Act. That's Section 35, and that comes up, specifies that later. It's going to cover the establishment of a new intergovernmental financial relationship and fiscal arrangements to support the exercise of lawmaking powers and other authorities under this agreement. 10 years only. Same thing you get, it's only this fiscal agreement, which again is not part of this agreement. You won't know and even see what that's about. And here, wow, this is the purpose of this is, it says implementation. Now you'd think that implementation is part of it. Again, no. In section 16.6a, it's a chapter called Implementation. The term of the implementation plan is 10 years from the effective date. It may be extended. Whenever you hear may, you don't have it. The only thing it says here is the plan is 10 years. Not implementation, but the term of the implementation plan. 16.6a, the implementation plan does not form part of this agreement. Goes further. It's not a contract. It's not binding. It's not a treaty, which means you can't enforce some kind of treaty under Section 35. This is critical, and it goes on. So basically, you're reading this stuff. You could write gobbledygook here. You could write, I want to hear more from Janice Switlo here, and put it in agreement. It would make no damn difference. This means nothing, so ignore Chapter 16 completely. Also, it says, what's the purpose? A framework for oh God, who are the lawyers on this? My God. A framework for negotiating future self-government agreements between the parties. Now, you hear that, you suspect there's a framework for negotiation, right? Agreed to, forming part of the agreement. Nope, sorry, you'd be mistaken. Section 15.19. It's one sentence. I'm sorry. You appreciate I'm a lawyer, okay? And when I see this kind of thing, it's just unbelievable to think that this is in any agreement, okay, to begin with. Never one mind that is actually causing you to capitulate if you go along with this, right? That's such a serious thing. Anyway, what's this section that's comprised of one line? Approval of future self-government agreements. Except as agreed to in writing by the parties, future self-government agreements will be approved in accordance with this agreement. Now, what does that actually mean? It means The people will not be involved. The people will not approve. The people will not be involved in this. It's the umbrella body. You know, so essentially you sign off on this. This is going to be your last vote on any of this kind of stuff. So, yeah, I mean, can I swear? Unfrickin' real. You know? General provisions. Very clear. What is this? This agreement is based on the recognition that the inherent right of self-government is an existing Aboriginal right within the meaning of Section 35 of the Constitution Act. I'm not going to repeat what I have to say about Section 35. There's quite a bit on that already that I've not only written about over the years, but also, of course, in the various episodes. Again, this agreement is not a treaty within the meaning of Section 35. And remember, you can never do a treaty because you can only do possibly a land claim, but there'd be no reason to do that with you. Because as I said, once you come under Canada, once you say you're under Canada, then you're agreeing that Canada owns everything. Okay, so fiduciary relationship, you know, as the First Nation exercises power and other authority under this agreement, fiduciary obligations of Canada will be determined by the courts. Here's a key, right? Yes, you're coming under Canada. Why? Section 3.7, the Canadian Charter of Rights and Freedoms applies to each First Nation government and the Anishinabek Nation Government in respect of all matters within their authority. So this is clearly, they said government to government, it's under Canada. The Charter does not apply to Indigenous nations. There's a lot more I could say about this, but you know, I really, in the interest of time, want to kind of skip to some of the major things, and even then I've got so much to say on that aspect. So, remember that the members of the First Nations who are Canadian citizens or permanent residents of Canada continue to be entitled to all the rights and benefits of other Canadian citizens or permanent residents. Section 3.19. This is critical. No party will challenge the validity of any provision of this agreement or the federal legislation that gives effect to this agreement. Now here, if you want a good deal, you know, good set of lawyers would say, okay, attached as a schedule to this agreement is the legislation that the federal government intends to introduce and pass. And it's a requirement for this to actually be binding that the federal government pass a law that's in substantially the same form as that attached as the schedule. And that forms a term of the agreement. But instead, what do you have? You can't challenge it. So they pass whatever they want. You can't challenge it on any means. You can't say it doesn't comply with the agreement. And for instance, I know a lot of people, you know, when I was talking about the First Nation Land Management Act, right? They're like, oh, well, but the agreement says this. And I'm like, well, so what? What the agreement says, it's the act that is the law that binds. So they're making this clear, you know, we'll decide what to pass and you can't challenge it. So you're not involved in the drafting. You cannot challenge it. The only, and you'll get later, you can see what role you do play. And that's you're going to be consulted, okay? Oh, well, let me take you to there. Section 1517. Here's what you actually get to do. Consultation on federal legislation, section 15.17. Canada will consult with the First Nations in the preparation of the federal legislation by, here's how they're going to consult, okay? They're going to provide drafts of their legislation, a reasonable opportunity for the First Nations to present their comments on the draft legislation, and a timely written response to any comments received from the First Nation. So you're entitled to comment And they'll give you a written response like, thank you for your comments. And that meets this section. Again, not good enough. You want something to be, you actually want, let's assume this is a deal that was written well and is something you actually want, then you make sure you get it, and you do that by scheduling a substantial form of the law. So basically this is premature if you want it to actually do something or mean something. Now, proof of laws. And I don't know if people will follow this with me, but let me give it a try. That you got a court proceeding. So federal legislation is going to provide for, judicial notice so that the courts will take note that, yes, these are laws. Normally, when you introduce a law into a proceeding or a document that is in the proceeding, you don't produce the original, you do a certified copy. What that requires is someone like a lawyer or a notary who actually looks at the original and looks at the copy and certifies by using their stamp and their reputation and their requirements by their governing body to say if it is in fact the true case, a true copy, and that gets submitted. Now, in this case of these things, whatever's going to be passed, it can be certified to be a true copy by a person authorized by that First Nation or the Anishinabek Nation, respectively, without proof of that person's signature or official title. So I don't even know how that's envisioned, right? But it's completely contrary to normal standards. But it gets worse. Further on, we'll come across it. I'll deal with it right now. Picture this. The other thing is that a law is not void or invalid because the procedures that are required in dealing with it and publishing it, for instance, are not followed. So you can have a situation where there's a law considered in effect, but nobody knows about it because it hasn't been published. Now, let's get into some politics, right? And let's get into some chiefs who are worried about the control and power that the umbrella body now has, and they're challenging one of the laws, maybe the leadership law, okay? Who controls the big pot, because that's really what it's about, big pot of money. Here you have chiefs maybe coming in and saying, you didn't follow our law. We said we needed this many people and this functions, and this is how this is to be done. In response to that, and you've gone into the federal court or the provincial court, as the case may be, because both have jurisdiction, and you go in and you say this, and you present the law that you know. Their defense, they come in and they flash a document that's quote-unquote certified true copy, but we don't even really know who's done that because we don't have proof of a signature, so anybody could sign for anybody. They might not even have a title, but there it is. And under this agreement, that's good enough. So they can change the goalposts. The court would be bound to accept that. Say, oh no, that was the previous version. This is the current version. And of course, that current version benefits those who are reshaping things for their own personal benefit without any checks and balances. That's not how you run government. So Chapter 4 is the incorporation of the umbrella company, the Anishinabek Nation, that it's going to be called. It's created as a new legal entity. Now it speaks in section 4.2, the Anishinabek Nation has adopted and will maintain a written constitution. Now, I don't know if anyone's seen this. I haven't. So who knows what that is in terms of what it contains. And each First Nation will approve it no later than the date it ratifies this agreement. Again, not the people, right? And I don't know how you ratify. I don't know how the chief can approve this thing without having seen it at the same time that the agreement gets ratified, right? But here's the curiosity. The next language says that this Constitution will address, among other things, some stuff. Does it exist already or not? If it exists, why the heck isn't it an attachment as a schedule to this agreement? What are you trying to hide? They're accountable to themselves. They'll control all the bodies. There's going to be no checks and balances. So you'll have a really large pot of money in the hands of a few, again with chiefs stuck in the middle. The people are not involved at all. Now, the exercise of lawmaking powers, etc., will be in a manner consistent with this agreement. Section 4.6, it will evolve over time. So they're giving heads up. This is going to change. How? We don't know, right? That's all for those individuals to decide for themselves. An Anishinabek Nation law enacted under this agreement will not be considered void, invalid, or unenforceable, nor will any person's liability under a law be affected by reason only of a defect in form or failure of the nation to comply with the notice provisions, etc. That's what I was just talking about a few minutes ago. Defect in form, that's pretty broad. Defect in form can also mean, this isn't even legible, right? And I've seen some of that coming out of this region. Leadership selection, the Anishinabek Nation's power to enact laws. Since it can evolve, as I mentioned before, that can become a dictatorship. They're going to have, doing stuff with respect to rights, privileges, and responsibilities associated with being a member. Now remember, person who's a member of the First Nation that's incorporated is also deemed to be a member of the incorporated umbrella company, the Anishinaabe Nation, okay? Because they're two separate legal entities. And Anishinaabe Nation wants to say that they represent and control the people. And so they're making them deemed, you have no choice in this, you're going to become members of this umbrella company too. It doesn't give you any powers. It basically gives the umbrella company the right to say, okay, I got 2,000 people here, so give me the going rate per head and pay it into my coffers so we can do what we want with it. The Anishinaabe Nation has the power to enact laws with respect to preservation, promotion, and development of Anishinaabe culture and languages. So they're going to control all that stuff, again, not the people. Power, management and operation of the government, not the people. Here's one to think about. Okay, so they can do all this stuff, no checks and balances. They can make laws with respect to the personal immunity from civil liability of employees, officers, elected officials, etc. They can absolve themselves from liability. They can also delegate their duties to an entity. They can enter agreements to receive a delegation of lawmaking authority. So there's, basically the incorporation will allow this entity to receive other delegated powers from Canadian governments if that's what they choose to do. Again, no more decision making. Here's what you get, right? Here's the big get. It's not even consultation, okay, as you've come to understand that terminology. The Anishinaabe Nation will provide an opportunity, not actual, just the opportunity, to the members and to any person who resides on a reserve of a First Nation and, not or, and who may be directly and significantly affected by any proposed law or decision of the Anishinaabe Nation under this agreement, to make representations about that law or decision in accordance with the principles of procedural fairness. Who decides if you are directly or significantly affected? This is wow, right? And again, any institution can do the same thing. Let's worst case scenario, Child and Family Services Institute. Well, it's not covered in here, but what can happen next, right, is because all this authority is wrapped up into these two entities. Canada can deal with just the umbrella corporation. They can enter into a Child and Family Services deal under Bill C-92 and establish an institution. and they can say, they can make a decision, and then, as I said, who decides if someone's directly or insignificantly affected? If all are affected, that may not be an individual because it's a person, not the community, right? So very, very dangerous stuff for individuals, right? Participation, only those who are directly and significantly affected by the institution can participate. But again, no decision-making power. Nothing goes back to the people. This is a heck of a lot of power to put in the hands of an entity that's going to pass its own leadership selection agreement, and the people don't even know what that's going to look like. Chapter 5 is where they incorporate the individual bands. 5.2 requires that each band maintains a written constitution. And it has to ratify that constitution prior to the date of ratifying this agreement. So this is why the big mystery, the big push for membership codes, election codes, and constitutions. That's all because it's intended to funnel into this ANGA. Wow. How do people do this to their own? I don't get that. Okay, so again, the same thing that happens with the umbrella company. The individual incorporated entities, artificial entities, are to exercise its power in a manner consistent with this agreement. It will evolve over time. They can change themselves too. Again, people are out of it. You're gone once you make this. So, person entitled 5.17. Again, the link. If you're entitled to be registered as an Indian under the Indian Act, you'll continue to be entitled to be registered as an Indian under the Indian Act after the membership codes and stuff come into play. Laws about preservation, promotion of culture and language. Now, remember, when it talks about First Nation, it's not the people; it's the legal entity that's created by the federal government, and we don't even know what that's going to look like because there is no sample legislation attached as a schedule with which they would have to comply substantially, or there is no deal. So it's I don't even know how to describe this. Again, personal immunities can be provided for, and delegation can happen. Any of the authorities can be delegated, right? So who knows who you're going to be dealing with, right? People will be, well, it's not my, I can't do anything. It's so-and-so over there. Again, that whole thing about you only get to make representations if you're directly and significantly affected by a law or an institution and how they're running things. You're really muted. I mean, you really are gagged. This is so, talk about being opposite to how an Indigenous nation functions, where that circle is large, where everyone has a right to be heard and considered, and the decision is made together. This is nothing like this at all. This is a corporate structure, okay? Enforcement can provide. Okay, adjudication, who has jurisdiction, right? Federal Court of Canada, Ontario Court of Justice, jurisdiction to deal with any issues, right? Here's another one. Ignore Chapter 7, Intergovernmental Forum. It's look how short it is to begin with. But it says the initial terms of reference for the operation of the Intergovernmental Forum are set out in Schedule B. But guess what? Schedule B does not form part of the agreement. And it's wholly, even if it did, it's wholly inadequate. I mean, Schedule B. Okay, this is a intergovernmental forum. Terms of reference, you know what that would normally look like? Maybe 10 pages, 5 pages at least. Look at this, bullets. Well, they don't care. They just got something down there that you'll think, oh, okay, this exists, right? There is nothing agreed to. They say, oh, we're going to have one. There's no agreement, there is no commitment by Canada to have anything of the sort. And why would they, once they've got you, once they've incorporated you? They don't need to do those things. So why do you think they would? They won't. fiscal, again, what else is not part of the agreement? The fiscal arrangements. I mean, God, what is part of this? Just giving up, right? That's the only part that's really part of this, that forms part of it. But nothing that what do you get in return for capitulating? What do you get for giving up and saying, okay, we're not anything. Under Section 35, based on doctrine of discovery, we're just remnants of former beasts of the field, and we'd like to become something, so please, Canada, incorporate us. To become artificial entities. Going back to those preambles that contain Anishinaabe language. It's so distressing. If you believe in what's set out in the preambles that are, you won't even see this, right? That's the thing. They don't have to give you the agreements. You don't have access. You don't have access to take an agreement to someone you trust as an advisor or legal or otherwise, or an elder, and say, what do you think about this? An elder, a true elder, could take this in their hands, go into ceremony and know, right? I don't know if they still exist even, well, I know, well, I shouldn't say that. I do know they do, because I've talked with people who do consult and do get advice. So again, 8.8, the Anishinaabe Nation Fiscal Agreement does not form part of this agreement, does not alter any rights or obligations, will not be used to interpret this agreement, etc. Okay? So you might as well not even read Chapter 8. All it does, it sets out a whole bunch of stuff here on the effective agreement. The fiscal agreement will set out all this stuff. How do you know it will? You don't have it. There's nothing requiring it. Why is it even here when it's not part of the agreement? Once you pass this, if you do, only the union guys, only the Union Ontario Indians, whoever, whatever form of dictatorship or oligarchy they put in place, they're going to be dealing with the money issues. Okay. Talks about accountability and stuff in this Section 8, but remember, Chapter 8 is not part, the fiscal agreement is not part of the agreement. So anything it says, it talks about in accordance with the fiscal agreement, they'll be, accountable in accordance with that. What is that? No idea. Sorry, and I'll try to pick it up. We're almost through, okay? Transitional. Again, remember I was talking about how things will change in terms of structure. 10.2, until a First Nation enacts a leadership selection law under this agreement, the election procedures that apply on the effective date will continue to apply. So that's anticipated, a leadership selection law for each incorporated band. And then for the umbrella corporation, the Grand Council, Ogima, all that set up, and the chiefs of the bands, they will be the Grand Council until, this is Section 10.4, until the Anishinabek Nation selects its representatives under its leadership selection law. Who makes that law? Themselves, not the First Nations, not the members. So it starts as a body of all chiefs, but it definitely isn't going to stay that way. Wow. And then we have, Indian Act transition. You're basically trading the Indian Act in some parts of the Indian Act. You're reaffirming that the Indian Act still applies to you in all of respects, but in some areas you're accepting a new law. You have no idea what it's going to look like, because remember, the feds will pass that law in whatever shape, form they decide, and once they pass that law, you can never challenge it. It could be the most racist law in the history of mankind, and you will not be able to challenge it. You'll have to accept it. So you've got the known Indian Act. We know what areas are unconstitutional. We know which ones interfere with governance. But now you're accepting all of the Indian Act, and you're accepting some unknown implementation act that will replace portions of the Indian Act. That is not anything like a step of acting in under your jurisdiction. Here it is, 10.10. As soon as practicable after the effective date, so as soon as this comes into effect after feds pass the legislation, each First Nation will, that means must, enact a leadership selection law. You're incorporated, so it's not the people passing this, remember. It's the directors of the corporation, not the people. They're going to pass the financial administration law and others. For First Nation Fiscal Management Act, has already done that. Why isn't this done up front, again, and scheduled? As soon as practicable, the Anishinabek Nation will enact a leadership selection law and a financial administration law. Again, these things should be ready, attached to schedules, so when the people are asked to vote in a ratification vote, that they'll know exactly what is going to be what. Instead, you're just blindly handing over your power and capitulating. Application of federal laws, application of provincial laws, everything still applies, right? And so it says, okay, for greater certainty, things, here's the list that these matters are not included at all, right? Criminal law, criminal procedure, labor relations, working, etc. What is this? It's limited to things like language and culture, just like you see in Bill C-92. It's no aspects of sovereignty. Now, again, if you don't believe that you come under Canada, there's a conflict of laws area, right? That allows Canada, again, for other matters of overriding national importance, their laws are going to comply. Excuse me. Again, it's only Canada. Under Section 1114, we're talking about international legal obligations. Remember, you're no longer, you've taken yourself out of your nation. You're no longer part of an international entity. And it says, Canada will let you know, well, not you, the people, but the Umbrella Corp, let you know if there's a question of that comes to the attention of regarding an international legal obligation. And if requested by Canada, the First Nation and the Anishinabek Nation, those two corporations, will assist Canada in the preparation of Canada's position, including, so, you're not there in your own capacity, but, you'll provide evidence that if Canada needs it from you, but you're there clearly under Canada. It's Canada's issue, not yours. Keep in mind that the Anishinaabe Nation Fiscal Agreement will join together the fiscal agreements for this agreement and the Anishinaabe Educational Fiscal Transfer Agreement into a single fiscal agreement. Wouldn't you want to know what that's going to kind of look like before agreeing to this? Education's a pretty big deal. First Nations Fiscal Agreement. Well, again, you don't know what that's going to look like. They're not giving you any indication, and they don't have to. Future, this is another one of these. Sorry, I'm just getting tired. Chapter 13, Future Negotiations. The parties may agree to negotiate additional self-government agreements. This is, just ignore it, right? Because I can agree with you to, become the Queen of Sheba. It's like, this is nothing. But what you see here, people don't understand that. And lay people, they don't understand, they aren't expected to understand these kinds of things. There's a whole list of things here, A through R of jurisdictional issues. Oh, we're going to be doing all this, well, you're not going to be deciding on any of that. You won't have a power to vote on any of that. That will be decisions of the umbrella corporation and the individual corporations, maybe. We don't know. And where there is an agreement to negotiate. If you don't have an agreement to negotiate, there is nothing, right? You can say that we might do this, we might do that. It's got no business being in an agreement. It's just designed to confuse, mislead, sound good, make it seem like, but don't be fooled by that. Who's going to amend this? Only Grand Council, so the head corporation will amend this agreement. Ratification, we don't know. There's no ratification process. It's referenced in 14.6 as existing, but it's unknown. Ratification chapter 15, ratification protocol undefined, not scheduled. You don't have any idea what needs to be done. There's no access to actual agreements. Reasonable steps to inform its eligible voters of this agreement, but not give access to this agreement, but how you can vote. So here's where it gets dicey. If it doesn't pass on this first one, remember it's only 25% plus 1, then you get a chance to do a second vote. But guess what? Whatever this ratification protocol was that they're supposedly following, which you don't know, so we can never determine if it was followed, the ratification protocol will apply to the second vote with necessary modifications to get that vote passed, right? So watch out for that. And after the vote, they'll meet within 21 days after the ratification vote to discuss any implications and any further course of action. So just because you vote it down, it's not over. Again, section 15.17, consultation, we've already covered that. You have no input on the legislation. Implementation, I've covered that, not part of the agreement. Dispute resolution, notice this. There's dispute resolution provided if it's between one or more incorporated bands in Canada, or the umbrella corporation in Canada, or one or more of the incorporated bands and the umbrella corporation in Canada. But guess what's not here? There is no dispute mechanism for anything that arises between the incorporated Indian bands and the umbrella corporation. Arbitration under our Ontario Arbitration Act. There's nothing under, international arbitration procedures. Here's another thing that cannot be challenged. Well, it would have to, I guess. I'm not sure how you would do it otherwise, but a dispute, this is section 17.22, a dispute related to the calculation of the transfer payment will not be referred to arbitration. Here we have the province of Ontario section. You see that? Parties affirm they're prepared to enter into discussions with the government of Ontario with respect to matters arising from this agreement with a view to ensuring effective implementation of this agreement. Well, again, this means nothing. Ontario's not at the table, but if there are aspects of implementation of this agreement that require Ontario to be on board, then Ontario better be there. And why would you sign anything until such time as that is actually resolved? Why would they even ask you to vote on it? There's no representation, warranty, condition, or collateral agreement affecting this agreement. This is the entire agreement, section 19.1. So don't accept anything that's said. If you can, insist on the agreement. But that's not what they're doing. They're giving you promo items. They're giving you summaries that they say. Again, following schedules, chapter 20. Following documents are attached but do not form part of this agreement. Schedule B, Anishinabek Nation Canada Intergovernmental Forum Terms of Reference. There are none. Now, here's what's interesting. This is only initialed by two people. I was surprised to see that. As I said, I expected the chiefs to be involved in the negotiations, you would think, right? I would have expected to see a lot more initials here. But it's clear that the chiefs did not have an actual role in this. Only that provincial corporation did. Schedule B, remember, it's nothing. So there you have it, a bunch of nothing. But Canada gets everything. What do you get? You get a body that is not only arm's length away from you, that you have no access to, that will control a large transfer agreement, transfer money. If it happens, there's no way to make it happen. It's subject to what the elected government of the day decides. In a nutshell, run. Don't agree with this. Vote it down. Put the provincial corporation on notice. Who gave you this authority to represent us, the people? Because that doesn't come from what the province does in terms of incorporating a body. So people, please hang on to your authorities. Please hang on to your nationality. Please don't be fooled. This is not a step of exercising your jurisdiction. It's the complete opposite. And that's all I have to say.